Hello and welcome back to another video on my channel. Today I'm going to be I say attempting, to review Stanford's Storm AI. This is a scholarly article generator, and essentially we have not had luck on the past two attempts because it said that the topics that I wanted it to generate an article on were too sensitive, and I disagree with that. I think they're highly relevant and current. So to me, that's not a very good sign. I'm very uncomfortable with being told what is an okay idea and what is not an okay idea, especially considering this is coming from an academic um, resource, and so that makes me really uncomfortable. I think it goes against sort of free speech and exploration of ideas. But with that aside, let's go ahead and try a different topic, one that should be entirely non-controversial. We're going to be, again, looking at, if you've seen the previous videos, the Brady right that defendants may or may not have prior to entering into a plea agreement. Currently, I'd say that they do not have it. I think that's clearly established, but there's a little bit of a circuit split on this issue. There's a little bit of reason to think that there are some situations where the court might grant it, or maybe the Supreme Court might have interest in expanding it. So without further ado, let's go ahead. I'm going to share my screen. All right. So first, this is totally free. You just have to agree to be part of their trial, their data collection. So we've done that. Now, here's our topic. Do defendants have a Brady right to access material exculpatory evidence before entering into a plea agreement? We only have 20 words, so you got to make them count. And then here you say what the purpose is. So sort of like your topic, thesis statement, and now what's the purpose? So I wanted to discuss relevant case law, including Brady versus Maryland. That is obviously the start of the progeny of cases that are going to create this due process right and expand it. It's rooted in the Fifth, but it's going to grow out from there. It's typically a trial right only, but we have some scenarios here where today over 90% of all federal convictions come from guilty pleas entered after plea bargaining. And so there's reason to think that as that the criminal justice system evolves and we see these new developments, that we should see changes to reflect that. Um, but anyway, you could argue this has been the case for a long time since, nearly the time of Brady versus Maryland. And if the courts wanted this, they would have done it already, but neither here nor there. Let's go ahead and see what we get. It may take up to 3 minutes. All right. I wish I had started the generation before I finished blabbing. But, one of the important things to note here is what we're looking for is the circuit split. The circuit split's not, it's not as hotly contested as other issues, but we do have reason to think that the Seventh, the Ninth, and the Tenth circuits are in favor of expanding this right. They are the most likely circuits to expand it. While some of them, I think it was the Seventh, acknowledge that they have not expanded it. Another court like the Ninth has already done it, but they've done it without the Supreme Court's sort of authority. They've cited their own precedent instead of the most recent Supreme Court cases that should be relied upon. United States was O'Heary in the 10th Circuit arguably has already done this, although that was a very unique situation procedurally where due process, your right to material exculpatory evidence at trial should have already kicked in, allowing evidence prior to, for the defendants to prepare with. And so that plea entry was entered into like the 11th hour, the day of trial. And, they should have already had the material exculpatory evidence. So where the court granted it there, they weren't really going with this, speaking to this problem, but it does fall in that category. It does fall in that box. So if we see that, that's great. Now, the number one most important case we should be getting out of this is the Alvarez case. It's an en banc hearing from the Fifth Circuit. They analyze it, they talk about the circuit split. So if we get the Alvarez case, that's great. The other thing is the most recent case that I'm aware of is from 2022, 2023, I think, and it's Mansfield versus Williamson County, also from the Fifth Circuit, affirming their prior position, which is against it. We could also look for the First Circuit, Second, and Fourth in the Mathur case, the Friedman case, and the Masoui case. So let's see what we get. And let's just look at how long this is. Balancing interests, racial disparities in plea bargaining. Um, okay. Coercive nature. So yeah, this is the fear of a trial penalty. It's funny. This is looking good. Implications of the Brady right. Has significant implications for defendants entering plea agreements, their ability to make informed decisions. Critics argue that the current application of Brady right does not adequately protect defendants in a pre-plea context, as it often fails to ensure that individuals are fully aware of exculpatory evidence prior to making critical decisions about their cases. Oh, dude, I like this. They mentioned the ABA model rules. This is an argument that typically gets brought up, and saying why, prosecutors already have certain obligations. Let's just go a little bit further, and it's in line with the ABA. Um, Prosecutors are obligated to disclose favorable evidence during plea negotiations. This obligation extends even to information that may be inadmissible in court. I'd want to fact check that, to be honest. ABA's Model Rule 3.8 stipulates that prosecutors must disclose evidence or information, includes exculpatory, that incomplete, yeah, decision making prior to entering a plea. Does it talk about the plea? I'm not too sure it specifically said plea. Oh wow, it gives us a nice scholarly article about this, and it gives us the highlights for the source that it pulled from. Can y'all hear me all right? Let's see. My mic's way over here. I really like this. Over 90%. Yeah, it really uses the same 11 site a lot, more than 5 times in a row. So if this were a legal article, you wouldn't really like that. Yeah, I don't think you want to cite, Supra or id, the same source more than 5 times in a row, generally. Let's see what 9 is. How do I just go to a list of sources? And I'm getting articles about this. This one's a case. Okay, cool. So this is a tool that will pull cases. The problem is I'm completely unaware of the utility of the Buffy versus Ballard case. Um, all right, it seems relevant. I'm not familiar with it. False exonerations. Some argue that disclosing exculpatory evidence may lead innocent defendants to enter pleas based on incomplete understandings of the evidence or the consequences. This could lead individuals pleading guilty to crimes they didn't commit. How's that a false exoneration? Allowing access to Yeah, I mean, I totally agree with everything this paragraph has said. Is that a concern about false exoneration? I mean, to me, a false exoneration, if I'm not, completely ignorant here, that's proving someone's innocence where they are not innocent. But here, what you're describing is innocent people pleading guilty. So I don't know why I titled it that way, but I'm being nitpicky. Um, we're getting a lot on Brady versus Maryland, which makes sense because we asked about it, but is the Buffy versus Ballard case? Oh, let's see. Okay, it looks like we're getting into the circuit split, guys. The implication of the Brady right in the context of plea bargaining have sparked significant debate among legal scholars, practitioners, and courts, while some federal appeals courts, including Seventh, Ninth, and Tenth Circuits, have affirmed the necessity for such disclosures. Guys, this might be even better than, and this might be the best tool for researching on this cutting edge issue. First, second, fourth, and fifth argue that there is no constitutional mandate. Guys, this is really impressive. I'd say Storm identified the circuit split correctly, better than Lexis AI, better than mid-page. This is great. If I were starting research on this cutting edge question and I came to Storm AI first, this would be by far the most efficient tool. And I'm assuming the circuit split. was addressed in either this fourth or this fifth reference. Yeah. Here it is. Circuit split. Are Brady claims available? The defendants who plead. Wow. Okay, guys, I'm going to go ahead and say that I'm impressed. I think this is a great tool for starting your legal research, especially in the context of a cutting edge legal issue. Maybe if this were already a more established area, mid-page would be a better bet. But for here, I'm going to say this is a good tool. And we'll just end the video there. It should be on your radar. You should consider using it if you're a student who's allowed to use AI for preparation on a moot court problem, which tends to be a cutting edge issue with a lot of law review, secondary sources written on it. Um, yeah, then you should really be utilizing this tool at your disposal if you're allowed to. And over time, we're going to see more and more rules allowing these sorts of uses because this just isn't going anywhere, and its utility is undeniable. So, all right, guys. With all that being said, I hope you enjoyed the video. Subscribe for more, and have a good rest of your day.